Okay, everyone. Good evening. This is Alice O'Brien, NEA General Counsel. Thank you so much for joining us tonight. Um, we are so happy to have you here. We are going to be talking tonight about certain new federal protections for employees in the current crisis. In particular, we're going to be talking about new federal law mandates for sick leave and family leave and new federal unemployment funding and flexibility to help out employees. To help walk us through all that, I'm going to turn in a minute to our two resident experts, NEA Staff Counsel, Kira McNett, who will be talking about the leave issues, and NEA Deputy Counsel, Jason Walta, who will be talking about the unemployment issues. The benefits that we are talking about today are the result of laws that were just passed in response to the current crisis. And while the protections that they provide are important and much needed, they are the beginning and not the end of the support that we know everyone needs and our public schools need in order to come back from the crisis. Before turning this over to Kira, I want to ask you all to take a minute to let Congress know that much, much more is needed to help us all rise together out of this crisis. If you could go to the national campaign slide, that would be great. We all know that this pandemic is having a devastating impact on our students and members, and that the worst is yet to come. State budgets and public education funding are very much at risk. The economic downturn could result in devastating cuts to education budgets next year. NEA has launched a national campaign to demand that Congress immediately pass legislation to stabilize public education funding for the upcoming school year, as well as to address the inequities impacting our students' opportunities and provide the necessary resources to protect our students and our members as they re-enter the workforce. Please go to nea.org/COVID action to see what you can do to support this national campaign. Our members and our students are depending on us to make sure that Congress acts. I also want you to know that as we go through the webinar tonight, we know that you will have questions. Next slide, please. Lots of questions. Please send them to us so we can answer them. You can send them to us at edaction@nea.org during the webinar or after the webinar, and we will be putting together and sending out an FAQ document that answers all the questions we receive. We plan on posting the FAQ and sending it to everyone who registered for the webinar, so you should be able to easily access the follow-up information. I also want to thank everyone who sent in questions in advance of today's webinar. We received hundreds of questions on everything from the sick and family leave and unemployment issues we are addressing tonight to several questions about the legal rights of educators facing potential returns to work. We plan on addressing those return to work issues in a separate webinar later in May, and we'll post and distribute information about that webinar in a few weeks. So turning to our topic for today, your leave and unemployment benefits, you need to know that what we're talking about today are new federal benefits, and that you likely have additional and even greater protections under your collective bargaining agreement if you're in a bargaining state, your school district policies, and state and local law. So your first step in figuring out the full spectrum of protections available to you is to check with your local union representative, as they will be able to tell you how you can figure out what leave and unemployment benefits are available to you under those state and local laws and agreements. On the federal side, the benefits we are talking about today come from two different laws. First, under the Families First Coronavirus Response Act, you are entitled this calendar year to paid sick leave and paid family leave, subject to certain caps and limitations, and Kira's going to talk about all that, for leave related to the current crisis. Second, under the CARES Act, your state can provide greater unemployment benefits to more types of employees and for longer periods than previously. And if you qualify for unemployment under your state law, the CARES Act provides for a $600 additional weekly benefit through the end of July of 2020. Next slide, please. I'm going to turn this over to Kira, who is going to go over the leave protections provided by the Families First Act first, and then she will turn it over to Jason to talk about the unemployment benefits provided by the CARES Act. Kira.
Thank you, Alice, and thank you to all of you joining us from across the country and to everyone who sent in questions. I'm going to talk about the two types of paid leave that are available now under the Families First Coronavirus Response Act, or the FFCRA. And, you know, this is the first time in US history that the federal government has mandated paid sick leave and some paid family leave across the board like this. It took a pandemic to get that, and this current program is only temporary. But it's worth noting that the crisis of the general lack of paid sick and caregiving leave in this country is one of the first issues Congress was forced to address during this unprecedented national emergency. The FFCRA provides two types of leave, which we'll be talking about today: paid sick leave and family leave to care for children during school closures. And as Alice mentioned, Jason will then be covering the CARES Act, which provides for expanded and additional unemployment benefits. Next slide, please. So the section I'm going to cover will be on paid sick and family leave. Next slide. So there are two types of leave under the FFCRA. The first type we're going to talk about is paid sick leave. A quick overview of the emergency paid sick leave law is that it creates a temporary paid sick leave requirement. It provides for a total of 80 hours of paid leave for coronavirus-related quarantines and illness. And the law divides leave up into two categories: one for your own care needs, where you receive pay at your full rate up to a cap. And the second category is the use of leave to care for someone else, which in those cases, pay is at 2/3 of your regular rate. Next slide. So in the first scenarios here, I can't work because I'm sick, or I can't work because I'm under quarantine. This new sick leave is available when you can't work or telework because of any of these three reasons. You're subject to a federal, state, or local quarantine or isolation order. You've been advised by a healthcare provider to self-quarantine, or you're experiencing coronavirus symptoms and are seeking a diagnosis. It's important to notice this part of the law that says you have to be unable to work or telework in order to qualify. For most educators in the country, where almost all public schools are currently closed, if you're continuing to work providing distance learning, the first two reasons for paid sick are probably not going to apply. If you're under a quarantine order or have been told by a doctor to self-quarantine, you should still be able to telework, assuming you're not also sick. However, if you are experiencing coronavirus symptoms and are feeling ill and you're seeking a diagnosis from your healthcare provider, you can take this paid sick leave away from your telework in order to care for yourself. So the seeking a diagnosis part is important in that you need to contact your doctor. If based on your symptoms, your doctor advises you to self-quarantine, even if you're unable to get tested, you should be able to use the sick leave. It's also worth noting that to use the leave for self-quarantining, this also has to be on the advice of your doctor. If you decide on your own without medical advice to self-quarantine, you won't be entitled to this sick leave benefit. Next slide. In these situations where the sick leave is for yourself, you're entitled to 80 hours at your full rate of pay, capped at $511 per day. And part-time employees receive an amount equivalent to the number of hours they ordinarily work over a 2-week period. Next, please. The next two scenarios are: I'm caring for someone who is sick or under quarantine, or I'm caring for my daughter because her school is closed. In these two situations, if you're unable to work or telework, paid sick is available for these reasons too. Next, please. When you're using the paid sick leave for these reasons, you're entitled to a total of 80 hours leave at 2/3 your normal rate of pay, capped at $200 a day. And again, part-time employees are entitled to the amount they ordinarily work over a 2-week period. Next, please. We've had a lot of questions coming in about what your relationship has to be to the person you're caring for in order to qualify for this leave. And there's 2 different reasons for leave that we've talked about here. They actually both have different relationship requirements. In the case of caring for someone else who is under quarantine, it can be anyone in your immediate family, someone you live with, or someone else who depends on you for care. But when it comes to being unable to work because a child's school or daycare is closed, it must be your child. This includes biological, adopted children, stepchildren, foster children under the age of 18. And it also includes children over 18 who are unable to care for themselves because of a physical or mental disability. Next, please. Some important things to be aware of about the emergency paid sick leave. It is available to use immediately, no matter how long you've worked for the employer. This leave can be used prior to any existing paid leave benefits. Employers can't require you to use other leave first. And it doesn't diminish any other rights or benefits you have under a collective bargaining agreement, another employer policy, or federal, state, or local law. So even if your employer has already provided sick leave for any other coronavirus-related reason, they still have to provide this additional sick leave now under the terms of the new law. And they can't reduce the sick leave you already have. One question we've gotten from several people is, what if I already had to take sick leave for something related to coronavirus? And the answer is going to depend on when you use that leave. The law went into effect on April 1st. So if you were required to use your ordinary sick leave for one of the reasons covered under this new law on or after April 1st, you probably are entitled to have the leave you used from your sick leave bank credited back to you. If, on the other hand, it was sick leave you used before April 1st, it wouldn't be covered by this law. So only leave going forward that's used for coronavirus-related sick leave, as we described, would be covered under this law. And in those cases, you should be able to use this federally required paid sick leave first before using any other kind of leave. It's also important to keep in mind that while this program will still be in place when some schools reopen in the fall, it does expire at the end of 2020. And any remaining emergency sick leave under this law is not going to roll over into the next calendar year. Next, please. All right. Also, when it comes to asserting your rights to this leave, be aware that it is illegal for an employer to retaliate against you for requesting or for taking leave. And if you're wrongfully denied leave, you may be able to seek relief by filing a complaint with the Department of Labor or by bringing a lawsuit. But of course, if you're denied leave that you think you're entitled to, be sure to notify your local representative as a good first step. Next, please. Another possibility with this sick leave is that you may be able to use it intermittently, meaning taking only a few hours a day or a couple of days per week. But employers are not required to allow intermittent leave. So you and your employer have to agree to this use. And this is almost always only going to be an option if you're teleworking. Next slide, please. Moving on now to the second type of leave provided by the FFCRA, the Emergency FMLA Expansion Act, which provides a temporary category of FMLA leave, which, unlike regular FMLA, is actually paid. This temporary expanded FMLA terminates at the end of 2020, and it can only be used to care for a son or daughter whose school or daycare is closed due to the pandemic. And it provides for a total of 12 weeks of leave, only 10 of which is paid. And pay is at 2/3 of your regular rate of pay, capped at $200 per day. And we'll get into some different scenarios involving this now, which hopefully will make a little more sense about how this works. Next slide, please. So in this scenario, you can access this leave if you can't work or telework because you're caring for a child who is home because their school or daycare is closed or their regular child care provider is not available. This includes not only paid childcare, but also if you have a grandparent or other relative who usually cares for a child, but they're unable to do so now. As we saw with the emergency paid sick law, to be eligible, it must be the case that you can't work or telework. And I'm going to get into that a little bit more later when we talk about intermittent leave. But the basic requirement is that to qualify for this leave, your caregiving duties for your child must prevent you even from teleworking. And this leave is for a total of 12 weeks. Again, the first 2 weeks are unpaid, but you can use the emergency paid sick leave during that time. Next, please. Again, this is limited to caring for your own son or daughter, as that is defined to include various parent-child relationships. And I'm going to get into this a little bit more because we had a number of questions coming in about whether this leave is available to people who are caring for children who are not their own. For example, a grandchild whose parents are also working. This is not an easy answer, but the FMLA has a pretty broad definition of the parent-child relationship, which includes anyone who acts in loco parentis to a child. There actually doesn't even have to be a legal or biological relationship, but that person has to be taking on the role of a parent. So you can be in loco parentis to a child, even if the parents are also present, as long as you're taking on a parental type of caregiving responsibility. This is an area where it's definitely worth asking for the leave. If, for example, you need to care for a grandchild whose parents are medical providers or first responders, and just to be aware that you may have to provide documentation to the employer in the form of a simple statement that you are acting in loco parentis to the child. We also had a number of questions coming in about taking this emergency paid FMLA leave to care for other family members. And unfortunately, it can only be used to care for children, your children when their school is closed, your children being broadly defined, but only for your children when school is closed. All of the other types of family, medical, and caregiving needs that may qualify you for regular FMLA are not included in this new paid leave. So you would have to look to whether you could at least take regular job protected FMLA. And remember also that you could probably take the emergency paid sick leave at least for up to 80 hours to care for a family member if the reason you need to care for them is for one of the COVID-related reasons that we discussed in the earlier slides. Next, please. We've also had several questions about what information you have to provide in order to be able to take this leave. Your employer can require you to provide a limited certification that includes the name of your child, the school or daycare that they go to, and a statement that no other suitable person is available to care for the child. Just to note the rulemaking on this, the DOL notes that employees shouldn't need to take this leave if they have another caregiver like a spouse or grandparent who's available to provide care to their kids. But the actual requirement is not that you prove up somehow that you don't have anybody else, but rather that you provide a statement that you don't have another suitable caregiver. And that is all that's been set out as the requirements of what you have to provide. Next, please. A few other important notes on this law. First, the only requirement for eligibility is that you've worked for the employer for at least 30 days. So that means it applies to employees who wouldn't ordinarily be covered by FMLA because they don't meet the 1 year and 1,250 hours requirement for regular unpaid FMLA. Unfortunately, however, for our members who are federal employees, this leave is probably not available, but the emergency paid sick leave is. So that's just a couple of notes on eligibility. Next, please. Not surprisingly, we got a lot of questions about how this new type of FMLA leave interacts with regular FMLA. For example, what if you've been off on leave with a new baby? Or what if you're planning to take FMLA later this year to recover from a scheduled surgery? It took a lot of people by surprise that the DOL decided in its rulemaking that this new category of temporary paid leave comes out of your same pot of regular FMLA leave. So if, for example, you already took 6 weeks of FMLA for maternity leave, you would only have 6 weeks of this paid leave to use within your employer's 12-month FMLA period. Or as another example, if you use all 12 weeks of this paid leave now and then need to take FMLA later, within the 12-month period, your employer could deny you the regular job protected leave. But there may be some exceptions here, such as where there's state family leave or short-term disability programs that may apply. And of course, there may be separate periods of family leave or short-term disability in collective bargaining agreements or existing employer policies. So it's always important to check those other potential sources of leave. Next, please. Another thing to be aware of is that paid FMLA leave may be used at the same time as other types of leave. This can be a really good thing if you want to use other leave to make up the remaining salary beyond the 2/3 pay, the $200 cap per day. But there's also the possibility that an employer requires what's called concurrent use along with other leave, like vacation or general PTO, in which case you'd have to use up vacation or PTO along with this expanded FMLA leave. There's a couple of really important restrictions on any employer requirement of concurrent use. You can't be required to take other leave during the time that you're using the emergency paid sick leave. And also any kind of leave you're required to take concurrently has to be leave that the employer generally allows for childcare purposes. So they probably can't require you, for example, to use sick leave, as that's something you would not ordinarily be able to use for childcare purposes. Finally, a really important caveat here, the issue of concurrent use of leave is almost always addressed in collective bargaining agreements or in a memorandum of understanding between the union and the employer. So if this issue comes up, you should always check with your local about it. Next slide. As with paid sick leave, retaliation for taking this paid parental leave is illegal, and there are enforcement mechanisms through the Department of Labor and private lawsuits. And again, you should be aware that as with regular FMLA, if you take expanded paid FMLA, you do have job restoration rights when you return to work. And also note that your health insurance continues while you're out on either type of FFCRA paid leave. Next slide, please. Again, not surprisingly, we got a ton of questions about this scenario. I'm working, providing remote instruction for my students while also trying to take care of my own children. As I think is probably the case for many parents who, and I can personally relate to this one, if you're fortunate enough to have ongoing employment and to be able to work from home, trying to juggle full-time work with caring for kids who have remote schooling is extraordinarily difficult. And many members who are parents working remotely have expressed that they're stretched almost to their breaking point. There's not a simple answer here because of the way the law is written and how DOL has interpreted the intermittent leave provisions. This is a situation we touched on earlier where the question is whether you are unable to telework because of your own childcare responsibilities. It may be that you can telework. You can provide some remote instruction for your students for part of your day or part of the week, but you really cannot reasonably work your full hours while also caring for a child who's home with you. And this is where intermittent leave can be very helpful. We're going to talk a little bit more about that. Next slide, please. So the catch is that, as I mentioned before, intermittent leave is not something you're automatically entitled to. As the law has been interpreted, employers are not required to provide intermittent leave. However, the DOL rule and all of the DOL guidance on this makes clear that the law is intended to encourage employers to be highly flexible in allowing telework agreements. And this suggests they should also be highly flexible in combining telework with some form of intermittent leave. So if having the ability to use the expanded paid FMLA for a couple hours a day or one day a week while also working remotely is something that would help you manage all of your responsibilities, you should definitely ask your employer about it. And if your school refuses to allow you to take intermittent leave, you should let your local representative know. This may be an issue that can be negotiated with the district either during present school closures or as part of the many issues that are going to need to be addressed as schools prepare to reopen. Many of those topics, we will touch on in a future webinar, as Alice mentioned. Next slide, please. And now that we've gone through the different scenarios where you have some new rights to leave while working, the last scenario here involves situations where the employer says they don't have work for you. This may be the case particularly for many of our education support professionals in districts that are not keeping all employees in pay status. And unfortunately, if you've been furloughed or laid off for lack of work, you're not entitled to any of the paid leave benefits under the FFCRA. You also can't use this leave to make up for lost hours if your hours have been cut due to lack of work. And this is where unemployment benefits become crucial. And that's where I'm going to hand it off to Jason Walta, who is our expert on unemployment insurance.
Hi, everybody. I am Jason Walta. I'm the Deputy General Counsel here at NEA. I am going to be talking about unemployment benefits, but before I do that, I just want to reiterate something that Alice put in the chat there, which is that we see all of your questions in the chat and we see all of your questions in the Q&A section. We are going to be, and we also know that we'll be receiving questions by email. We are going to be answering those posting those later in some form or other. But we're going to take all of those questions, we're going to go through them, and we're going to, sort them out and answer them. And so there will be a later document that's going to be available to everyone where we answer those questions. But given that there are over 900 people on the call right now, it's not going to be feasible for us to answer them in real time. So I will be talking about unemployment benefits here. Next slide, please. And just to put it in perspective, I want to just mention the unprecedented rise in unemployment that we've seen over the last 6 weeks. Over the last 6 weeks, the new unemployment numbers came out this morning. We're now at 30 million new claims for unemployment over the last 6 weeks. And just to put that into perspective, that is about 10% of the entire US population. It is about 20% of the US working population. So it's really something, it's really kind of a level of unemployment that we have never seen before and not really experienced before in modern times. And to deal with that, the federal government has taken steps to expand unemployment, both traditional unemployment and to expand unemployment for those who are not otherwise eligible for traditional unemployment. Next slide, please. Now, I'll say a little bit about how traditional unemployment works so that can kind of point out the areas where new changes have been made because of the weaknesses of our traditional unemployment system. It is administered by the state, and eligibility usually depends on a few things. One, it's only for employees, not independent contractors. You have to be unemployed through no fault of your own. Generally, you're not allowed to quit and collect unemployment insurance. And many employees are often excluded from unemployment because they lack the work and pay history. They haven't been working in a job long enough, or they haven't gotten paid enough in that job long enough to receive unemployment. And you also have to be able, available, and actively seeking work. The benefit calculations vary from state to state, but they're always based on prior earnings. There's often a 1-week period before you're eligible to receive benefits, and those benefits generally expire after 26 weeks. So that's kind of the landscape of traditional unemployment benefits. Next slide. And one thing that's, I think, of particular relevance here is what is called the between terms exclusion for school employees. And I think that a lot of people on this call are probably familiar with this, but that school employees generally aren't eligible for unemployment benefits over the summer if they have a contract or reasonable assurance of employment for the following year. Now, if a layoff occurs despite that contract or despite the reasonable assurances of reemployment, teachers and school employees can receive benefits. But if you want those benefits to be retroactive, you need to start applying for those benefits at the end of the term, as in at the beginning of the summer, and reapply every week after that. If you try to apply in the fall and ask for retroactive benefits, you will not be eligible. So if you are concerned about layoffs in the fall and you're a teacher, then the best way to protect your unemployment benefits is, even if you haven't received a layoff notice at the end of the school year, to apply for those benefits when school lets out and continue applying for them every week through the summer until you know whether you've been rehired in the fall or not. And if you have not been rehired in the fall, then you can receive those benefits retroactive to the beginning of the summer. This exclusion is required under federal law for teachers, and for ESPs and other school employees, it's generally a matter of state law. Next slide, please. So here's an overview of the federal government response to the coronavirus. One is that they have taken some more administrative measures to ease eligibility for traditional unemployment, and then they passed the CARES Act, and that expands traditional unemployment benefits. It creates a new unemployment benefit called the Pandemic Unemployment Assistance Program for workers who traditionally did not qualify for unemployment benefits. It introduces this $600 per week increase in benefits for all recipients until July 2020, and it encourages programs for partial benefits for employees whose hours are reduced. Next slide, please. So let's start with the easing of requirements for traditional unemployment benefits. And these are actions that have been taken by the Department of Labor. As I said before, you generally have to be unemployed through no fault of your own, that you did not quit. And the Department of Labor has come out with guidance that says that employees who are quarantined, who have to self-quarantine to avoid exposure, or who have to leave work to care for a family member and do not intend to return to work, can receive benefits, can receive traditional unemployment benefits. Those people are unemployed through no fault of their own. Another traditional requirement is that you have to be able, available, and actively seeking work, something that is incredibly hard to do in the current environment. The Department of Labor has said if you are temporarily laid off, or if you are quarantined and intend to return to work, you can receive benefits without applying for other jobs. Okay, next slide, please. So the CARES Act also expands on traditional unemployment benefits in three important ways. One is it provides funding to encourage states to waive the 1-week waiting period for unemployment benefits. It extends the maximum benefit period to 39 weeks. It's generally been 26 weeks in most states. And then it creates this additional benefit, this additional $600 per week for anyone who's receiving traditional unemployment benefits. And this additional $600 per week will last until July 31st, 2020. And that includes people who are receiving partial unemployment or people who are receiving full unemployment. Next slide, please. The CARES Act also creates a new benefit program that I mentioned before, the Pandemic Uninsurance Assistance Program for workers who don't qualify for traditional unemployment benefits. A few examples of these are gig workers, independent contractors, and workers who didn't have sufficient work history or pay history with an employer to receive benefits under the traditional program. Like the expanded benefits for the traditional program, the benefits go up to 39 weeks. And like those benefits as well, they're calculated based on the state's traditional formula, plus the $600 per week until July 31st, 2020. Next slide, please. Now, to be eligible for these new benefits under the Pandemic Unemployment Assistance Program, this new program, employees have to self-certify that they are unemployed. Their unemployment was caused by one of 11 COVID-related reasons. The Department of Labor has issued guidance that interprets these reasons narrowly. And one thing to be aware of is that these benefits are not available if you can telework with pay, or if you are already receiving some kind of fully paid leave, whether it's fully paid sick leave or fully paid vacation leave. And so what I'm going to do now is I'm going to discuss these various reasons for being out of work that make you eligible for this pandemic unemployment assistance program. Next slide. Now, the first is that the individual has been either diagnosed with COVID or is experiencing COVID symptoms and is seeking a diagnosis. The Department of Labor has taken a little bit of a narrow view on how to interpret this, and has said that if the individual is tested positive or diagnosed with COVID and continuing work, such as through telework, is not possible, that will make you qualified. And they've also said if you've had to quit due to coming in direct contact with someone who has tested positive and on the advice of a medical professional, you're required to resign in order to quarantine. That would be another reason that would make you eligible for these benefits under this new program. Next slide, please. The second reason is you have a member of your household who has been diagnosed with COVID and you've had to quit work for some reason related to that, whether it's because you've had to quarantine or because you need to care for them. That will make you eligible under this new program. This is a question that has come up quite a bit. An individual is providing care for a family or a household member who's been diagnosed with COVID-19. And the Department of Labor has specified that the care has to be of such an ongoing or constant, requiring ongoing and constant attention, that the individual's ability to perform work is severely limited, so that they either can't work or that they're limited in their hours. Next slide, please. This is another one that we've received a number of questions about. You can receive these benefits if you don't otherwise qualify for traditional unemployment. If you have a child or dependent who is unable to attend school or another facility, such as a daycare, that has been closed as a direct result of COVID-19, and that this school or facility is required for the individual to work. Now, a couple of important points on this. One is that a school is not closed for these purposes at the end of the school year. Once school is out, school is out. But if the facility that you're relying on for summer care is also closed due to COVID-19, then you still continue to qualify. And this benefit can also be available to those who telework, but whose child care requires such, again, ongoing and constant attention that it's not possible for you to perform work at home. Next slide, please. The fifth reason that makes you eligible for this new benefit is that you are unable to reach your place of employment because of a COVID-19 quarantine. The Department of Labor has specified that unable to reach the place of employment means that doing so would require a violation of a state or municipal order restricting travel. So in the absence of such an order, you would not be able to take advantage of this reason for getting benefits. Next slide. The sixth reason is that the individual is unable to reach the place of employment because a healthcare provider has advised to self-quarantine due to concerns related to COVID. The Department of Labor has taken a very narrow view on this. They say that the medical professional has to advise you that you are either infected or that you must self-quarantine because of something like an autoimmune condition that makes the risks of contracting COVID greater for you because of your condition. The Department of Labor has emphasized that voluntarily quitting your job out of a general concern about exposure to COVID does not make you eligible under this program. Next slide, please. The seventh reason is that the individual was scheduled to start employment but does not have a job or is unable to reach the job as a direct result of COVID-19. The Department of Labor has said that you must be unable to reach the job because doing so would require the violation of a state or local order, or the employer has closed the business or rescinded the job as a direct result of COVID. I want to pause on this slide because it responds to a lot of the questions we've already gotten about summer employment and whether losing that summer employment will make you eligible for some kind of unemployment benefits. This would be the category that you would want to focus on. This could be a helpful category for educators who had a summer job scheduled and who are now unable to take that job due to either travel restrictions because the employer is closed or because the employer has rescinded the job for COVID-related reasons. Next slide, please. Number 8, the individual has become the breadwinner or major support for a household because the head of the household has died from COVID-19. I think what they're imagining here is a scenario where the breadwinner isn't just sick and out of work because of COVID, because in that circumstance, there would be other benefits available to them, either their own unemployment insurance or some kind of leave benefits. This is where someone would be pushed into the workforce where they hadn't been before because of a death in the family. Number 9 is the individual quits his or her job as a direct result of COVID-19. Again, this is something that the Department of Labor has construed quite narrowly, and they say that it's really limited to circumstances where an individual had COVID. They no longer had COVID, but because of the health effects of being sick, they're no longer able to work. The Department of Labor has again emphasized that voluntarily quitting your job out of a general concern about exposure to COVID-19 does not make you eligible for this benefit. Next slide, please. Number 10, an individual's place of employment is closed as a direct result of COVID. The Department of Labor has said that that must be shut down due to an emergency declaration or necessary social distancing protocols. It does not seem to apply to a business closing that's just part of a general economic downturn due to COVID. Next slide, please. The CARES Act gives the Department of Labor some additional authority to kind of create its own reasons why these benefits have been available. The Department of Labor has been very stingy on that. The only additional reason that they have identified is for independent contractors like Uber drivers or other gig workers who don't have a specific place of employment, but who are unavailable or unable to work because of the COVID-19 crisis. And so that rounds out the 11 reasons that you can become eligible for this new unemployment benefit created by the CARES Act. So next slide. As I mentioned before, the CARES Act creates a $600 per week increase in the benefit amount for all unemployment recipients. This applies to both the traditional unemployment that you would receive under state law and the new CARES Act benefits for those who don't qualify for traditional unemployment. This benefit, as I said before, expires on July 31st, 2020, unless Congress decides to extend it. And importantly, this benefit is not reduced or prorated for partial unemployment or a low base benefits amount. The Department of Labor has said if you receive $1 in base unemployment benefits, you receive the full $600 per week for as long as you're on unemployment up until July 31st, 2020. But you cannot quit your job because the unemployment benefits you would receive with the extra $600 are more than the wages you'd get. Next slide, please. The CARES Act also has provisions that encourage partial unemployment. Some states already provide for partial unemployment so that if your hours are reduced, you can receive a partial benefit. The new benefits that are created for employees who don't generally qualify for traditional unemployment, those are extended to people who become partially unemployed for a COVID-19 related reason. And finally, the CARES Act provides federal funding for short-term or shared work compensation programs that are in place in about half the states right now. We expect there to be more. And under these programs, an employer makes an agreement with the state unemployment agency to reduce employee hours somewhere between 10 and 60%. The employees get paid for those reduced hours, but they also receive a prorated unemployment benefit. And up until July 31st, that benefit would be with the additional $600 per week. Next slide. When it comes to filing for unemployment, the claims for traditional unemployment and for the expanded CARES Act benefits are all done with the state's unemployment agency. But I want to issue a word of caution here. Many state agencies have been very slow to adjust to this. Their websites for the applications are overwhelmed. They have not reconfigured their websites for the applications on the new benefits. So these benefits have been very slow to be paid out and have been very slow to be processed. Next slide, please. I have a few kind of question and answer scenarios that I think would be helpful to run through. The first one, am I eligible for unemployment benefits if I'm a teacher and I'm furloughed next fall? Yes, if you're furloughed in the fall, you will be eligible for benefits. But recall what I said earlier about the between terms exclusion. If you wait until the fall to apply, you will only be able to recover benefits beginning at the time of your application. If you are worried about being furloughed in the fall, then you should begin applying at the beginning of the summer. The only way to recover full retroactive benefits is to apply at the end of the term, and again, every week after that until your application is accepted. And once it is accepted, you can get retroactive benefits. Next slide, please. If I'm furloughed for 1 day a week, will I still receive the additional $600 per week? The answer to that is yes. If you are eligible, again, to receive $1 of unemployment benefits, you will receive the additional $600 per week until July 31st, 2020. But whether you can receive partial unemployment benefits for reduced hours largely depends on state law. The CARES Act encourages it, but it doesn't require states to provide partial unemployment benefits. Next slide, please. If I lose the summer job that I usually work, am I entitled to unemployment? This is a question that we got a lot by email in the run-up to our webinar here. And the answer is if you were already scheduled to commence a summer job, then you may be eligible for unemployment under the expanded CARES Act benefits, regardless of whether you have a reasonable expectation of your school employment in the fall. Now, to be eligible, you have to be able to self-certify. And that means, swear on, in a document that the summer employer, that you had this employment lined up and that the summer employer either closed the place of employment or has rescinded the job offer as a direct result of a COVID emergency. Next slide, please. So that's it for the Q&As on this. I wanted to say a few words, although it's really kind of beyond the scope of the unemployment thing, is about health insurance coverage in the event of unemployment. One option is your health continuation coverage, often referred to as COBRA. The downside of this is that as the employee, you pay the full cost of the coverage. We're hoping that a future stimulus bill will include subsidies for continuation of coverage, but as of yet, that hasn't happened. Another option is Medicaid, where you may have greater access in states that have expanded eligibility under the Affordable Care Act. Again, we're hoping that legislation could expand Medicaid nationwide to lower income adults, and especially people aged 50 to 64 with chronic conditions who are especially vulnerable to the COVID crisis. And finally, another option is the health insurance marketplace. These are individual policies that are potentially subsidized under the Affordable Care Act. And so those are kind of the three primary options that you would be looking at for health insurance in the event of unemployment. Next slide. And this is where I turn it back to Alice to finish us up here.
Thank you, Jason, and thank you, Kira, for all the information. I know this is a lot of information for everybody to take in, and I know people have questions. I hope that the information we presented answered many of your questions, but we are also preparing, as we said earlier, we'll be preparing a follow-up FAQ document to answer the questions that came in during the webinar tonight. And either in the chat box or in the Q&A box, we will pick them all up and, bucket them together and answer them and get that out to you. If you have further questions, you can send them to us by emailing edaction@nea.org. There are also some resources here that you can look at. The Department of Labor has FAQs that you can look at as well. We will be providing the PowerPoint presentation to everybody as a handout, and this webinar in its entirety will be available for people to view. I think we have one additional slide that we wanted to just remind people about, if you could go ahead, and which is this. You know, our country is in a crisis. As Jason said, we have a fifth of working families in this country who are unemployed at this point, and tens of thousands of people have died. We know that our economy is really in a terrible situation and that our public schools are going to take a tremendous hit come fall unless Congress takes more significant and sweeping action to stabilize our public education funding and provide opportunities for all students and protect our students and our members. So please take some time to go to nea.org/COVID action and join our national campaign to push Congress to do more to help all of us. And thank you all for joining us tonight. Stay safe, stay well. Take care.